Good evening, everyone. I'm Felicity Gerry, King's Counsel, member of Libertas Chambers. Welcome to our webinar this evening, which is the best way to develop the law on complicity, also known as joint enterprise, with our guest, Professor Matthew Dyson from Corpus Christi College in Oxford. I'll introduce him to you at the moment, but just to inform you that this webinar is being recorded. You're welcome to have your cameras on, but we would be grateful if you keep yourselves on mute whilst Professor Dyson is speaking. The chat facility is available. I'll try and moderate that while he's giving us our Libertas Chambers lecture. So do feel free to put questions in there. I will join in a little later on and tell you a few stories in my experience in the 7 years since Jogi was decided by the UK Supreme Court, 7 years this week, and then we will have time for a Q&A session at the end. Okay, so off we go. This webinar, the best way to develop the current law on complicity, also known as joint enterprise, has been developed because there are concerns rising about the incarceration of accessories to murder for increasingly long periods of time. So we're here to consider the current substantive law of complicity and where it could be improved. The focus of this evening's webinar is on the physical components of the crime, and Professor Dyson will suggest there are tools available in the law already to improve the law, particularly picking out the need for a substantial contribution by the accomplice and a sufficiently high level of fault. Now, for those of you who don't know Professor Dyson, he was a key team expert on the defence team in the Jogi appeal. Frankly, we can't underestimate the impact that his evidence had in that case. He is now director of the Institute for European Comparative Law at the University of Oxford. He is also president of the European Society for Comparative Legal History. He's Professor of Civil and Criminal Law at the University of Oxford and a tutorial fellow at Corpus Christi College in Oxford. So squirreling away there, Matt, in your garret that it looks like behind you. Welcome. Thank you so much for joining us this evening. If you could kindly take yourself off mute, I'll shut myself up, and you have about 30 minutes to tell us how can we be doing joint enterprise better, please.
Thank you very much. It's a real pleasure to be here, and particularly to mark a milestone with Felicity, 7 years since the decision in Jogi. There's so many things we could talk about in the time we have. I'm going to focus on just a few, and as Felicity said, my focus is going to be particularly on the physical component in complicity. I should probably start, though, with a few ground clearing comments. So first off, I have a view about whether Jogi is a good decision, whether it's a perfect decision, whether it's a bad decision. That's not actually my focus. I'm going to be looking particularly on how we can make the law even better. Second, there's plenty of things we could talk about terminology. I won't be using the language of joint enterprise, largely because the Supreme Court has, in the last decade, tried to move away from using it. Now, I know some people find it helpful. I certainly find that when I'm dealing with students, and particularly with the media, they love the term joint enterprise. They think it's a helpful one. I'm afraid I've reached a stage some years ago where I don't think it's helpful. It could include joint principals, normal accomplices, and those who are liable under what at least Professor J.C. Smith called parasitic accessorial liability, where in the course of committing one crime, another one grows out of it, and you're liable for that second crime parasitically on your liability for the first. Each of those are very different things: joint principals, complicity, and parasitic accessorial liability. So I will tend not to talk about joint enterprise. I think it can be misleading. But I will typically talk about complicity and parasitic accessorial liability. Another comment, of course, not only are there lots of different views on this, but I'm coming at this from an academic's perspective. I'm lucky I've got to work with some really interesting practitioners, Felicity included, and I'd like to think I understand a little about how the courts deal with these kinds of cases, but I clearly don't understand it with the level of detail that solicitors, barristers, and those who are personally involved in these cases do. So I'm interested in the law as a set of rules to try to make society a better place. And so I can't claim to understand all of the complexities. Similarly, I don't speak about the personal impact that these kinds of cases have on individuals. That's just not something I know as much about, but I'm happy to learn if that's something we need to do tonight. So with those bits of ground clearing out of the way, I'm just going to talk a little bit about the position in Jogee before I move on to consider the law and how it could be improved into the future. So the position in Jogee itself is a partial answer to some of the questions that we had in Complicity. Underlying the whole area of law is a simple enough question. When should you be liable in criminal law for the crime committed by another? We normally break this down into two parts. When are you responsible for another's action? And when are you culpable in respect of another's action? So here, responsibility is doing language work essentially to connect you to another person's activity. Is this somebody you instructed to act? Is this somebody you were supposed to stop acting and you didn't? Is it someone who you are in some sense responsible for? And the second half then is culpability. Did you perform your acts which generate responsibility in a way that's culpable, blameworthy? So, for instance, if you have no idea the other person is going to kill and you lend a knife, typically you're not going to be liable because you're not connected to what they then do with that knife when they kill. You thought they were going to carve a turkey, they killed a human being, you're not connected to it because you weren't culpable. We can then have a discussion about exactly what fault will make you culpable. There's a large range of issues between no awareness at all and it was your purpose as well. So we break down to work out whether you're liable in respect of another person's crime. We tend to ask questions which push out, are you responsible and are you culpable? There are other ways in the background about how you're connected to people's crimes, which we should at least be aware of. Now, one of those ways would be vicarious liability, typically phrased as the employer's liability for the actions of an employee or the crimes or the torts of an employee. This is imperfect in criminal law and tends not to be used actively. So criminal law has relatively limited use of vicarious liability. That would be one way that the criminal law could make you liable for the crimes of someone else. Tort law uses it extensively. Criminal law uses it only in a minor way. Corporate liability is another way that you could be connected to the crimes or activities of others, and criminal law has particular rules about it. We don't need to consider them here because criminal liability via corporate liability is relatively specialized and doesn't tend to come up in the majority of the situations we're talking about. So if we're focusing in on complicity, the other person we need to contrast these rules with is the principal, the person who actually commits the crime. English law is, I'll say bad, but I don't think it's exceptionally bad at defining the principal. And what I mean by that is many legal systems struggle to have a very clear test up front for who is the person who commits the crime. You might imagine it was simple enough. The person who brings about the thing that's prohibited, doing so with whatever fault is required, intending the crime, for instance, would be the principal. Well, let me give you a few examples to show you how this can blur into each other. First off, imagine a defendant who wishes to kill the victim, and the defendant also has an accomplice who is going to help. The defendant takes out a knife and stabs the victim. So far, easy. The defendant is the principal, the victim has passed away. What if just before doing so, the accomplice had closed the door to the room and locked it in order to keep the victim inside the room? Well, again, that sounds relatively simple because the accomplice has assisted or encouraged the crime of the principal. What if instead of being that far removed, the accomplice held on to the victim, immobilizing the victim, allowing the defendant to stab and kill? Well, easy enough there as well, because the defendant would be the principal again, and the accomplice would remain the accessory. But what if the person holding the knife is immobile, holding a knife firmly forward, and the person who previously we thought to be the accessory pushes the victim onto the knife? At that point, we might have to consider that the person pushing the victim, though not holding the knife, becomes the principal. And at a certain point, if both the person holding the knife and the person holding the victim push forward towards the center point at the same time, you might end up with co-principals. So the difference between a moment of pushing forward or merely immobilizing can be your difference between an accessory and a principal. None of this gets caught at a matter of doctrine. The courts and academics have come up with almost no test for this. It's left to the courts to apply based on the facts as they appear. But I think that what's really important to hold on to is in English law, in practice, at the stage of trial process and sentencing, there is no formal difference between the accessory and the principal. So whenever we notice something that isn't perfect, what ends up happening is we end up saying, well, we can just treat these two classes alike and deal with it at sentencing, if at all. So while we don't have a good definition of who the principal is, and that also means we tend to not have a good definition of who the accessory is, we treat them all together as the same. The logic behind that is that sometimes we don't know in a particular given set of facts who was the accomplice and who was the principal. The classic sort of locked room murder, except that we know that one person did it and one person assisted and one person died. One answer is to say, well, you can convict neither of them because you must know which is the principal. Another version says you convict them both as principals because you know at least one of them did it. And the third version, which we don't use, says convict them both as accessories. Now, English law takes the position that we simply prosecute them both as principals and convict them as principals, knowing that one of them is being convicted as a principal who actually only assisted, but not thinking it's important. So there's an evidential problem sometimes behind these rules. But there's also a claim that is often made by prosecutors that beneath it all is an equality. Once you're involved in a crime in more than a minimal way, you can and should be treated as if you were the person who brought it about. And that kind of logic feeds into an argument about why we shouldn't bother distinguishing between principals and accessories very much. That kind of reasoning is often expressed as they were all in it together. It was a common purpose, a common plan. It just so happened that one of them was stabbing and one of them was holding the victim. It just so happens that one of them was the lookout, whereas in fact, that was unimportant. They were each trying to take a full part in the crime. That kind of logic is very important in multiple places when you see the law playing out in practice, because it is the link between the evidence that's obtainable and the claims of satisfying the test in Joghi. So now that we come to it and we're trying to identify the accessory, what do we see? Well, the test in Joghi is relatively clear. In terms of physical contribution, to be liable for any particular crime, the secondary party or accessory must assist or encourage that crime. Trouble is, we don't have any definitions for what assisting or encouraging mean. The relevant legislation, the 1861 Accessories and Abettors Act, Section 8, says aid, abet, counsel, or procure. Now, abet and counsel effectively mean the same thing. Abet was when you were present at the time of the crime, and counsel was when you were not present at the time of the crime, but in both those cases, it's where you're encouraging. Aid and assist, no difference in the meaning. But the original legislative text also refers to procuring, which the court in Joghi were not dealing with. They didn't speak about it at all, and many people regard that as a bit of a gap. I think in reality, it just wasn't engaged in the facts, and many, many situations of procuring are often dealt with under assisting or encouraging. There is probably a special place where procuring must still exist, and I think it does still exist in the law without difficulty. If there's people want to talk about that in the questions, we absolutely can. But for present purposes, I'm going to focus on assist or encourage. Assistance is supposed to mean some sort of physical contribution towards the crime, such as making it easier by providing a weapon, dropping the defendant off at the relevant place to commit the crime, giving intelligence about the planned activities that were necessary, such as the means to commit a crime or a particular code to break into a safe, etc. But also, assistance can include making something in some sense less dangerous. So providing protective equipment, in some way making the crime easier to commit. There is no clear test for how much of a contribution that must be. The other area, encouraging, previously known as abetting or counselling, similarly has a very vague test. Essentially, you must encourage, but once the jury decides that there is encouraging, there is very little way that that can be challenged. What kinds of things would constitute encouraging? Well, the minimum is that whatever it was said, done, written to communicate encouragement must have been able to reach the principal offender. So if you shout into the wind, go on, do it, Jimmy, kill, and it's completely impossible for Jimmy to hear you, then you can't be liable under encouragement. But say you shout it and Jimmy, in fact, really doesn't like you and is more likely to do the opposite of what you say than what you say. Well, in that situation, the law currently says you'll still be liable for encouraging him. There is no way to exclude the kinds of evidence of encouraging on the basis that it wouldn't be likely to or didn't have an actual effect on the individual. And in this sense, encouraging is treated even more harshly than the very minimal tests we have in assisting. The reason for this, probably, is that it's very hard to tell how much of an impact you have on somebody else's mind. The law has essentially said, we don't want to try to work out what effect this had. And as a consequence, we say, largely, there must be no effect at all. This was a decision called Kalheim, which was approved by the Supreme Court in Joghi. The decision is actually not as extreme as it's been taken, and indeed not as far as Joghi has taken it. In a moment, I'll tell you what I think the best interpretation of the law as is now should be. But on the other hand, just to clarify, it's commonly thought that there are no specific tests for establishing the minimum amount of actual contribution through assistance or encouragement that the secondary party must offer towards the principal's crime. So once we've established whatever this is, a minimum amount of connection in terms of responsibility for the other's crime, we then turn to establish what the relevant fault was. So, for example, the first step is that you must do your own actions deliberately and intentionally. If you accidentally help somebody to commit a crime, you're not going to be liable for it normally. I say this, but it doesn't really do much in practice because there are other components of liability which do a lot more work. So for this one to do work, the other ones would have to be satisfied, but this one wasn't. So for example, let's assume the other test is you have to at least intend to assist the other. So you intended to assist them, but at that moment you accidentally did it. So you intended to assist them tomorrow when you thought the crime should be committed, but you end up helping them today accidentally by revealing the location of the victim. I'm not sure there's going to be much sympathy in the average jury if you were planning to help the person tomorrow and you just helped them accidentally early. And so as you can imagine, this kind of component doesn't get tested very often in actual cases. But nonetheless, in theory, you should be deliberately or intentionally doing your own action. Next step, you must intend to assist or encourage, as appropriate, the principal. You must be intending to further their plan in some way. This does not mean that you have to intend the crime to take place, though many have argued that it does. The Supreme Court was very clear on this. They said, you may be uninterested. You may have no particular view on whether a crime will take place at all, but you must intend to assist or encourage that person. I tend to call these cases disinterested assistors. The kind of example I'm thinking of is based on a case called National Coal Board and Gamble. A man is approaching a weighbridge. He's in a large truck filled with coal. The weighbridge assesses the amount of money he, on behalf of his employer, will ultimately have to pay to take ownership of the coal and take it onto a public road. But it's possible to leave the weighbridge, to come off it, and not go onto the public road. The weighbridge operator weighs the truck with the coal in and says to the driver, "You are overweight." meaning you are not allowed on the public road weighing that much because you exceed the relevant weight limit for the roads near here. The driver says, I'll take the risk. The response from the weighbridge operator is to hand over the chit, which is a necessary component in the driver being able to leave the weighbridge and get paid for his job, also to take ownership of the coal potentially. Because the weighbridge operator doesn't care. He is completely neutral on whether the vehicle leaves the weighbridge and goes onto the public road or not. As far as he's concerned, so long as the weighbridge is clear in a moment so that further vehicles can approach it, he doesn't mind what happens to the truck. That person, to me, is disinterested, perhaps even uncaring about whether or not a crime is committed, but was convicted for it. He believed a crime would happen. It wasn't necessary for the lorry to commit a crime just by handing over the chit, because the lorry could leave the weighbridge and not go onto a public road. But probably he believed that the crime would take place and he was liable on that basis. But it was in no part of the weighbridge operator's purpose that the crime take place. He didn't care. So these kinds of disinterested assistor cases are a little bit tricky, but they are very rare, partly because the narrative I've already mentioned. The classic way these cases are put forward is as a group of people who all have the same common criminal purpose. So they're all in it together. They all intend the crime to take place. The first requirement was that you intend your own act. The second requirement was that you intend to assist or encourage. There are further requirements. Some of them are only really going to be active depending on the particular facts of the case. So, for example, if it's a particular crime that happens and the defendant wants to say, but I didn't realize it would be that exact crime, then the law responds, well, so long as this was one of the group of crimes you considered would take place, that's enough. It doesn't have to be that you intended that particular branch, the Stoke Newington branch of the Midland Bank. In the case of Bainbridge in 1960, for example, it could be you intended a bank to be robbed, that's enough. Similarly, if it was, as in Maxwell and the DPP for Northern Ireland, a situation where there could be multiple sectarian forms of violence, they were all within those that you'd considered. When it turned out it's a bomb, you can't complain. So that won't always be relevant, but sometimes it is. The last two bits which are very relevant are, one, what I call the principal precondition. That's to say, you must know enough that if you did happen to know all of the law, that you would know this was criminal. So the way this works out is, again, the turkey and the knife example. If I don't know enough to realize that you might do something criminal, I shouldn't be liable for it. So I intend to assist you by handing you the knife, but I think you're going to carve a turkey. If you intend to stab a human being, I haven't reached what I call the principal precondition. This is visible in paragraphs 9 and 16 of the judgment in Joghi, where the court talks about you being aware of, knowing enough about what would happen. Now, in paragraph 9, it's about existing facts, and paragraph 16 refers to the plan, the principle's future projection. And essentially, you must know enough that we say this is criminal. You don't have to know all of the law, but you have to know enough of the things which the criminal law says turn this into criminality. And the last example of fault is that if the crime is one requiring fault, you have to intend that the principal have it. Now, this is a little bit tricky. The example that the Supreme Court uses is the difference between theft and taking without consent. You may have heard of crimes relating to joyriding. These are covered in section 12 and 12A of the Theft Act 1968. Essentially, normal theft requires you intend to deprive the owner of that property permanently. So if you intend to borrow it for a day and then you don't care what happens to it afterwards, you might even intend to return it. It can't be theft. And we have a couple of specific offences, one in particular relating to taking vehicles, commonly called taking without consent or twocking under section 12 of the Theft Act, which have all the other component parts of theft except the intention permanently to deprive. So this is a way to test the difference between intending the crime to take place, simple enough, or in intending that the principal have the fault for the crime. So, for example, if I support you in taking a vehicle, thinking you intend to borrow it, but in fact you intend to take it and deprive the owner of it permanently, then I do not intend that you have the full fault requirements for theft, because I do not intend that you intend to deprive the owner of it permanently. So far as we're concerned, I think you only intend to borrow it. As a consequence, I can only be liable for the taking without consent offence, even though you can be liable for theft of the vehicle. This is a very powerful tool which was inserted by the Supreme Court. It ties in with some of the earlier works, particularly of Lord Toulson, who had been on the panel and who, with Lord Hughes, wrote the judgment. The reason it's so powerful is it's a way to keep people from falling into murder liability very easily. Because prior to this, it was quite simple to convict people, secondary parties, tangentially connected to the crime, for all the possible crimes, including homicide, which anyone within the group who committed the offences committed. Now, in those days, you need only foresee the possibility of a second crime, such as murder, taking place. You only needed to foresee it, and you didn't need to think it was likely, just that it was possible. You could have been against it, but so long as you foresaw it as possible and carried on, you could be liable. This was the parasitic accessorial liability, and you did not need to contribute to it at all. Jogee removed this form of liability, parasitic accessorial complicity, in two ways. First off, by requiring you to assist or encourage every crime, and second off, by saying you had to intend to assist or encourage every crime. But even though you're going to be liable in some way for this second crime, the question will become, well, what crime will you be liable for, even though you are connected to someone who does commit murder? And so this is what this final form of fault I'm mentioning does. If I support you in committing a crime, and I intend for you, for example, to kill, then I'm liable for murder when you kill. But if I merely intend to support you in committing a violent attack, and I intend you only to cause some harm, and you end up killing, perhaps even intending to kill, I can't be liable for the murder. I can be liable for homicide, such as by unlawful act manslaughter. But because I did not intend for you to have the fault required for murder, in other words, I did not intend that you intend to kill or cause grievous bodily harm, I can't be liable for your murder. So it reinstated a possibility where the secondary party is liable for less than the principal. So what I've just tried to do here is sketch out in relatively simple terms the two major parts of what Jogee has done for the law of complicity. First, it didn't change a great deal in the normal test for whether you're responsible for the crime of another, you've assisted or encouraged it. But you'll have noticed one thing it did do is by removing parasitic accessorial liability. It meant that for each crime, you must assist or encourage it. Prior to this, you could assist or encourage a first crime, out of which a second crime arises, and you'd be liable more easily for the second crime than the first. But since after Jogee, you must assist or encourage every individual crime, though it hasn't changed the definition of assisting or encouraging, it has kept that as the core standard of complicity. Then for culpability in the crime of the other, well, what do you have to do there? There's various forms of tests, but I've summarized them for you as you must intend your own act, you must intend to assist or encourage, you must know the essential elements, essentially what I've called the principal precondition that make it criminal. Where multiple crimes are involved, this need only be one of the crimes that you contemplated. And if the crime requires fault, you must intend the principal to have that fault. So from that position, what can we do going forward? Well, there's a number of things within fault I'd love to talk about, but the focus of today is on physical contribution. Some of the particular fault issues concern conditional intention. If there's time towards the end, I'll try to mention that a little. But to focus now on the physical contribution. As I mentioned, there isn't a formal test to say how much contribution is enough. And that's the bit that I'm deeply concerned about. The nature of our criminal justice system relies heavily on lay people. 95% of cases never get past the magistrate's court, and the vast majority of magistrate court cases are heard by lay people. Those that do get past the magistrate's court rely, of course, on juries, who are predominantly, virtually exclusively made up of lay people. Of course, legally trained persons can sit on juries for some time now, but they still remain the vast minority. Lay people perform many valuable functions within our criminal justice system. They help to maintain against state tyranny. They help to make sure that the criminal law is intelligible to people in the wider society, such that it doesn't become too complicated or unable to be explained easily enough in a trial. But there is fundamentally a difference in how responsibility for the decision-making works when you involve lay people. Magistrates have to give reasons for their decisions, but juries do not. And the natural result of this is, if you seek to challenge a conviction achieved via a jury, the only things you can actually do are challenge the direction or hold on to some very vague hope that you could persuade a later court that no jury could possibly have come to this conclusion, which very rarely succeeds. So we end up repeatedly challenging trial judge directions as a means, as a proxy for saying the jury didn't make the right decision on the facts. And this in turn puts a lot of focus on what the directions from the judge are and what evidence the judge allows forward. It strikes me as remarkable that we allow evidence forward with very little constraint on how the prosecution spin their narrative. And the result is, if we combine that with tests that say any contribution is sufficient, it doesn't need to be marked as significant or sufficient, that people can be drawn into the net of criminality very, very easily. I won't go through all the boring detail of each of the cases, but my argument is essentially that it does not make sense to call somebody an accessory or an accomplice or a secondary party who was not actually assisted or encouraged, where you use the test of assistance or encouragement. Those verbs themselves require some form of contribution. Otherwise, what we would have in complicity is a form of inchoate liability. That's to say, liability where the full harm hasn't actually happened yet. Famous forms of this are attempts liability, conspiracy liability, or what used to be called incitement and is now called encouraging or assisting another to commit a crime. Those areas are expressly areas where the full offense doesn't have to take place. Whereas we treat complicity as derivative of the full crime taking place. If it is derivative of the full crime taking place, it does so on the basis that the secondary party has actually assisted or encouraged towards the crime. And yet we don't test for it. So within that, what can we do instead? Well, my argument is it is not difficult to ask for at least a substantial contribution towards the crime. The language of substantial contribution is not unknown in the rest of the criminal law and the wider law of England and Wales. Substantial here does not mean that the offence would not have taken place without the support of the accomplice. It could well be that, left to his own devices, the principal would have been able to kill the victim. But you provided a knife. Maybe other people would have provided knives as well, but yours was used. In that situation, there is likely to be a substantial contribution. But when you want to argue that there was a crowd of 50 people all present watching this fight happening, and it was said that by their presence they encouraged the two parties to fight and ultimately for the principal to kill, it's going to be a much harder thing to show that a random individual within that crowd substantially contributed to the crime. So substantial contribution doesn't mean that the test is now going to be impossible to show. It does mean that there is at least some minimum requirement that the prosecution are going to have to demonstrate about the contribution made by the secondary party. Picking up the word procurement I mentioned to you earlier, this is a specific form of complicity, which in my view actually already requires, and I think it's been largely acknowledged requires, forms of causation. The case law from the 1970s tends to suggest in that language we talked about bring about by endeavor as the closest way to describe procuring. And so it does require actual causation. Procuring does occasionally crop up still in cases, often in cases where there is no communication, so there won't be encouragement, and where in some sense the procuring is counter to the purpose of the principle. So for example, if I spike your drink, intending for you to realize you're intoxicated and not drive home, and so stay with me. In that situation, I'm not communicating the spiking to you, and I'm not furthering your purpose. So procuring is that I've caused you to be over the drink drive limit. Now, these kinds of cases already require causation, and they already require much higher levels of causation than the law needs to. And in fact, I would argue already recognizes a minimum requirement in respect of assistance or encouragement. It has been argued, for instance, by Keith Smith, that we could conceivably understand the law currently as offering a reverse burden of proof. If the relevant conduct looks like it could possibly be encouraging or assisting, then it will be up to the defendant to show that it wasn't. The snag with this approach is, in practice, it doesn't seem to be how cases are argued, because we find very few examples of somebody successfully showing that conduct wasn't assistance or encouragement. But also, there's long-standing case law going back to Wilmington and the DPP in 1935 that the criminal law has not a lot of favor for reverse burdens of proof for significant elements like this. Now, that has its other interesting elements to it. It's led to the growth of strict liability offenses instead of reverse burdens of proof of fault, which is probably a bad thing. But the idea of the presumption of innocence is itself inherently a good thing. So if we did improve the law by recognizing formally that you have to support the principle by offering a substantial contribution, would this mean that there would be failures to convict people who are quite sensibly responsible and culpable for the crime of another? I don't think so. I don't think it's going to suddenly generate more evidence, but what it will do is force the prosecution to articulate a much more detailed case than saying the defendants were in it together. It will also hopefully force them to give better quality evidence, to fight to get that evidence, rather than rely, as some cases have done, on cell site data from mobile phones demonstrating that a particular alleged accessory was nearby and was friends with the defendants and, quote unquote, must have known what was going to happen. The fact that juries convict on these kinds of cases is troubling to me, but of course I don't sit in the trials and I don't see all the evidence they do. But it seems like it's far too easy for prosecutors to argue that defendants were just purposely aiming for crime. There's a lot of interesting work here being done on the use of musical evidence, particularly from drill music, to suggest that those involved in any way in making those videos, because the videos refer to violence, must have a desire to cause violence, and so are accomplices when violence does happen by at least one member of the band. So what I've been trying to show you is that it's perfectly capable within the law now to set and articulate a particular standard for what the secondary party must do towards the principal's crime. And I've argued that standard should be substantial contribution. That fits within an overall framework demonstrating the responsibility the accessory has towards the crime of the principal. There are other component parts, as I've said, particularly in regards to fault. But there are deep questions and difficult questions about who the principal is and who the accessory are that do resurface in other places. And one of those is innocent agency. And this highlights again the difficulty with distinguishing between principals and accessories. If accessories don't have to contribute at all, it's always in the interest of the prosecution to cast any particular person in the role of accessory. In some instances, though, it's in the prosecution's interest to cast people as if they were principals. And this typically comes up where the crime is strict liability about some element, because in that situation, the principal does not need to know of this relevant thing, for instance, the age of the victim, whereas the secondary party would need to know of that age because they would need to know that fact, which, if they knew all of the law, would make them aware that this was criminal. So there are occasionally these important differences between whether somebody is an accessory or whether somebody is a principal. And our law is currently fudging that distinction. Therefore, having a clearer test for the contribution the accessory has to make will help us to distinguish between a principal and an accessory as well. That's the core of what I wanted to talk through today. I'm very happy to answer more questions, and there's more specific things I could tell you about, for instance, innocent agency or conditional intention. But I think for the moment, I'll hand back to Felicity.
Well, brilliant as ever, Matt. Thank you so much. Just picking up on a few things that you said. We don't have any questions in the chat, but obviously those of you who are here, please feel free to put your hands up, use the emoji, write in the chat, shout at us. I'm sure we can reply. But while you're thinking about your best questions, I thought I would pick up on a few things that you said, Matt. First of all, the use of language. Of course, I love the use of complicity. The New Zealand bar bought me a hat that said Felicity on complicity, which I have in my chambers in Melbourne, which I love. But I think what's really important here is the knock-on effect across the Commonwealth. If Jogee doesn't answer all the questions that we need to answer, as we hoped it might, then that has an effect across the Commonwealth. So I wanted to ask you this question. Why do you think it is that the Court of Appeal, particularly, are so resistant about contribution? We've had the recent decision of the case of Roe, and obviously we'll write something up for our audience afterwards, and I'll give the citation for that. But why is it, do you think, that we've got this sort of resistance to creating that connection between the alleged accessory and the crime that might have that structure that you're talking about?
Yeah, so there's some intellectual reasons and there's some practical reasons. Intellectually, I don't think once the courts had ruled out a but-for connection, that's to say you had to have this contribution for the crime to take place, they didn't feel there was an easy alternative of something less than that. And as such, intellectually, they didn't want to create a test out of nowhere. If they'd looked a little harder to how we'd use, for instance, in loss of self-control, well, let's say diminished responsibility is an easier example for the use of the word substantial, and contribution tests that we have elsewhere in the law, particularly in tort law, where substantial contribution or material contribution are used without significant difficulty. They might have had a tool they could use. More generally, though, there is a sense that the courts don't want to hamstring practical cases by saying you must have substantially contributed. I think that fear is perhaps overplayed. I don't understand how we can meaningfully say that a defendant is being convicted for having assisted or encouraged if we haven't shown any actual assistance or encouragement. And I don't know how we then help those persons who are convicted to understand the wrong that society is saying they've done and to be reformed in a prison process. There's decent evidence that people who have been convicted under what is sometimes called joint enterprise don't understand if or why they've been convicted, and so find it very difficult to then show remorse and receive parole as early as they would have done if they had been able to understand the claims that are being made about them. So I think the court is hamstrung somewhat because there wasn't a significant amount of detail on what the test might look like and how it would work. And I think also they're very concerned that they can't predict all of these cases or restrain too much. I also think a slightly different problem has been cases prior to Jogee, where the Court of Appeal has come down incredibly hard on resisting people getting appeals through out of time for having been convicted under the law pre-Jogee. I only know of one that absolutely clearly did, and another which I believe did, and there might be one or two others, but it's a very small number, despite these rules having been in place from 1985 until 2015-16.
Thanks, Matt. I've got another question for you, and then we'll go over to Charlotte, who's got a question for you, and it's in the chat. But you talked about the worry, if you like, about the way in which cases are put by the prosecution or opened by the prosecution. And I think a lot of us that appear in these cases are worried about every case being opened as a plan, the all in it together point. I think some prosecutors now don't use that phrase, but they'll go for common plan rather than all in it together, but it has the same sense and meaning in a criminal trial. Do you think we're blurring the distinction between conspiracy and complicity to the point that we can't identify the difference? Is that a problem? I think
it's interesting that's an example of the same problem I was describing, becoming an inchoate crime. because the more we look like conspiracy, the more we're relying on the crime not having taken place. And that's another funny thing about our approach to criminal justice, that we can sentence for an inchoate crime as if it were the full crime. So should we be punishing someone who pulls out a gun, pulls the trigger, but the gun misfires and so doesn't kill the target, to the same extent as the person who pulls out the gun, pulls the trigger, and it kills the victim? There's difficult questions of moral luck on our approaches to things, but fundamentally, as a matter of doctrine, the more we start to talk only about the agreement and use that to supply the evidence that we say is sufficient for complicity, the more we're relying on the minimum outcome effect that inchoate offences require. So I think it is troubling, but I can see why they do it, because what kind of evidence is usually available to them? They normally know that these defendants know each other. They might be able to show some past history, previous interactions. They love to try to describe some sort of gang, because as soon as you describe a group of people as being a gang, the implication is they're willing to break the law for a cause that's associated with that group. So once you have a group of people acting together described as a gang, you say this was their plan, because it's much simpler as a narrative to tell the jury that people who are doing these things outside society, this is against what we would normally regard as acceptable, they had a plan to do it, and that explains all of their actions. It's much harder for juries to, I imagine, to perceive the possibilities of joint action as being open to all situations and no clear plan, and then to still find these people liable for having intended to assist or encourage, or having intended that if the crime required fault, that it was intended.
Yeah, thanks. I mean, obviously already we see people with very chaotic lives, incapable of organising anything, and yet part of that alleged common plan. So we can think about all sorts of scenarios where that becomes really troubling in criminal trials. Charlotte, do you want to speak to us with your question, or shall I read it out? I can't quite see where you are on my screen. Can we hear you? Charlotte is in the chat. Just give her a moment, see if she can come on.
Hi.
There she is. Hi, Charlotte.
Hello.
Okay, so Charlotte Henry, whose brother Alex Henry, those of you who don't know can Google, who is currently serving a sentence for what, for the sake of argument, we'll call joint enterprise murder. Charlotte is a campaigner with the Jengba campaign, joint enterprise not guilty by association, and she is campaigning for her brother's release, and I'm instructed in her brother's case, so we're not going to talk about that today. But Charlotte is going to take the opportunity to ask Matt her question, which is in the chat for those of you who wish to read it as well. Go ahead, Charlotte.
Apologies for what I'm wearing. If you can see me, I'm in my pajamas. But Matt, where would you see the best opportunity for law reform? Would it be via common law, or legislation? So private members bill, for example, or the Law Commission?
So thanks, Charlotte. I think it depends which bit we want to fix. In respect of contribution in complicity, there is enough case law highlighting the difficulty with dismissing any formal test that I think the judges themselves can find this thread. I don't see a particular difficulty with that, and I don't object to it, since they're the ones who've controlled this threshold already by saying in most cases there isn't one, but imposing one for procuring. I don't think it requires Parliament. There are other issues which probably are parliamentary if the courts don't change their position. So, for instance, what is substantial injustice under the test for appealing after 28 days? The courts created that, but it appears that they're not going to change it anytime soon. It's one of the funny quirks of the timing of Joggi that it was exactly at the point when the UK decided that it would have a referendum on being inside or outside of the EU. And in my view, in some ways, luckily, attention in the media shifted quite dramatically towards the EU referendum, with the result that perhaps forces that would have argued that Joggi was a bad decision, forces I have to admit I don't agree with, but didn't get their airtime about it. And as a result, we didn't face legislation to undo it. But the last Law Commission report on this topic would have undone Jogee if it had been implemented after Jogee. Now, obviously, it wouldn't have referred to Jogee because it was about a decade earlier, but it had argued that there was still some value in quote unquote joint enterprise. Now, it did so probably on the basis, or at least plausibly on the basis, that Parliament, no government was going to remove parasitic access or a liability on its own. So I think there's reasons why it did what it did, and I think there are arguably some reasons why one might like specific rules for multiple crimes arising in the first. But in this particular case, I don't see for contribution legislation being necessary. I fear for changing appeal procedures, it might be. And I think in both cases, you would need a very strong popular movement to improve the law, because otherwise Parliament doesn't seem to want to spend any time on this.
Thank you both. Go on, Charlotte. Sorry, you were going to
Sorry,
answer.
I just another question for you, Felicity.
Oh, okay.
Would it ever be possible to judicially review a charging decision on the basis that charges should be brought under an attempt to assist or encourage rather than participation in the substantive offence?
Oh, now I'm going to duck that question today because we're not talking about judicial review. But what I'll do is take it on notice, as they say, and get someone to come and talk to us about judicial review. So I think it'd be really good to have another webinar on those types of questions, because I think there are some really interesting questions about judicial review of decisions to charge now. So I'll duck it for today, but I'll think about who we can have to come and give us a webinar on another day.
Oh, fantastic.
Right. What I would like to tell everyone is Matt's research and his published paper, which we'll link to in the article, the follow-up article from this webinar, is with the Court of Appeal, because I stood up a couple of weeks ago and gave it to them and tried to argue contribution and issues around knowledge and knowledge of the essential facts. I don't know how well it went down because I haven't yet received the decision. So we may or may not have some influence on the Court of Appeal, or we might have a reaction to Matt's research. So it's an ongoing issue. They've got it. Let's hope they can see the threads in the cases that Matt has referred to. And particularly the work of Lord Toulson. I would like to acknowledge Lord Toulson, who sat on the Jogee decision in the UK Supreme Court, the late Lord Toulson, sadly, whose work in the lead up to Jogee can be seen in both his academic writing and the cases that he was sitting in, and the first half of the Jogee decision that plainly matches some of the writing that he'd done before. So I'd really like to acknowledge that, because it's also his cases that come into this, isn't it, Matt? That, you know, that he was sort of looking for this question of contribution. So so a little acknowledgement for him, and a great sadness that he wasn't able to go on tour after Jogee and explain exactly how he intended it to work. We've got some comments about language in the chat that I'll leave you to read in your own time, but just a couple more questions, because we've got 5 more minutes, Matt. If I can just keep you 5 more minutes on a couple of questions that might help practitioners, and if they're too big, feel free to reject them. But I think one of the questions that comes up a lot is when you've got group violence, so we haven't got that situation of the type of plan that is a specific plan targeted at an individual, but group violence that ends in a death. How might we best make a distinction between murder and violent disorder for those who are accused of being secondary parties? I'm thinking particularly about those sorts of cases where overwhelming supervening acts have been discussed in manslaughter. So people turning up tooled up, groups of people having a fight and somebody dies. Can we get a handle on that from an academic perspective? How might we be able to say, well, here's the distinction between murder and violent disorder, or here's how an overwhelming supervening act might work in murder? If the question's too big, shrink it and give us the bit that you find interesting.
Yeah, it is a large question. And I don't necessarily have the skills that practitioners do to try and carve facts out. I would probably say this. It's very important to be specific about who is helping with which individual crime. The more the prosecution establish a situation which is violent to begin with, the more they're likely to be able to persuade about an intention the secondary party has that the principal have a particular fault. So it's got to be able to be resisted on the basis that on each level of fact, first off, what was this? Was this a tussle? Was this meant to be violent? Is violence actually what they're looking for? Is violence of any serious level? Including what were the consequences to these people of knowing violence? It can't be a simple story that they wanted blood and therefore they wanted to kill. It should be much more gradated about what was actually a plan or what was actually the reasons why two groups ended up in violence. As regards carving particular offences out, I'm not really sure of the best way to do this. I would say it's quite tricky. I know the CPS have a preference for, in a sense, more recent offences sometimes, and I know that they think public order offences can sometimes give the sense of greater violence in the background, but not always. I would say that overwhelming supervening event is something to be aware of. It's very undefined. And the case law on it post-Joggi seems, claims to treat it as if it wasn't a causation question, but they nonetheless use the language of pushing something into the background, of no longer connected, even though that is causal language. It's something my article went into, and I essentially argue that this is further evidence that it would be a lot clearer if we acknowledged at least a minimum connection between, in the form of substantial contribution, between the secondary party and the principal. Because if you don't have that, how are you then saying that if there was an overwhelming supervening event, that there shouldn't be liability anymore? Because what are you undoing? If it's only available where you did make a contribution, why, when you haven't made a contribution, i.e. you've done less to begin with, should there be fewer defences? It doesn't seem to make sense to me. So I think following a minimum contribution thread does help with the overwhelming supervening event angle, as well as also does it help with a withdrawal offence, if that's relevant on the facts.
I was going to ask you that one next. So yes, the connection allows us to work out when we're withdrawing and where there might be an overwhelming supervening act. So connection being that contribution, substantial contribution being that great thing that we could have to make it much clearer for all of us in these types of cases that involve multiple people being charged, particularly multiple children. And I think that's a major concern where we have multiple children being charged in these types of cases. I, of course, have loads of questions and can talk forever, Matt, but we have reached 6:59. So I think it's probably a good time for us to stop. I know that you'll have a handout for us, so I'll deal with that with you separately, and we will make sure that the video is posted as soon as possible. We will follow it up with an article in Libertas Lens. Follow everything that Professor Matthew Dyson does, because it's really insightful and really useful and also really practical. He's given us great things to think about in these types of cases, and also for any appeals that we're trying to have a go at, let's put it that way. And I'll let you all know the result of my appeal when I get it. So a big thank you to Professor Matthew Dyson. Thank you so much for coming to speak to us. I know you're really, really busy, and I really hope that the quality of your research is recognised by the Court of Appeal in the cases that we try and bring for these people who are frankly being convicted without any contribution being identified. So thank you for coming. Thank you for speaking to us. Thank you to all of our attendees today. I think we got up to 70, and to the other 135 who registered, thank you. We'll make sure you get the video. Thanks, Matt. Bye-bye.